Welcome once again to our continuing YouTube video series on business law. My name is Christopher Neufeld of Neufeld Legal. And in this particular YouTube video, we will be providing you with a cautionary tale about advancing shares to new employees without undertaking the proper prerequisites to protect yourself and your company when you issue those shares. And what I'm attempting to do in this video is not trying to necessarily entirely discourage you from providing shares to new employees, but instead to provide you with some background as to what you need to consider and what you're up against if you simply do what certain people have done in the past and it's come back to hurt them. So I won't be using names of actual clients or even industries to explain this story, to protect the mistaken, the foolhardy, let's call it. But instead what I'll do is I'll look to explain to you what happened and why it is so problematic. So what had happened is that there was a company in a very niche market space, and it was doing very well. And what they did is they looked to bring in a few additional employees. And as part of bringing on those employees, they decided, you know what, we'll give them a very small share percentage. We'll give them 0.5% of the outstanding shares in the company, maybe 1% of the shares in the company. And so they provided them with these shares. And they did it as a single line in a one-page employment offer letter that was the entire basis for the engagement of that particular individual. Actually, it was several individuals, but we'll focus on this one particular individual. So they gave him this maybe 0.5% of the shares in the company as part of bringing that individual on. It was listed there that the employment agreement by itself was problematic because it was only that one page, never worked on with a lawyer, but they had inserted, as part of your employment, we will provide you with this single share. So when did this become a problem? Well, this individual actually left a very short time afterwards. So they had left, let's say maybe 6 months, under a year after they had begun working with the company. However, the employment letter didn't really stipulate anything as to what happened with the shares. So that individual was in effect now a shareholder of the company with no real mechanism by which the company itself could reacquire those shares outside of paying some negotiated number. Well, a couple years go on, and this niche company continues to grow significantly. That a larger company in a different market, seeing the niche that this company was in, says, we want to acquire you. Now, so they look to go and acquire this particular company, and what do they find when they're doing their due diligence? Well, lo and behold, they find out that there are these smaller shareholders of 0.5% or 1% that need to be resolved. Well, several of them were still with the company, and this was not a problem whatsoever for them to effectuate a buyout. The problem was the one who had left. Now, he had left and he still had his shares, and he was a pretty clever person in some respects, and he was a bit shrewd and strategic in the sense that he decided that what he was going to do was he was going to push back. And given that there was no buyout arrangement in place and he held his shares free and clear, he was going to negotiate. So what happened with the negotiation? Well, technically, he was able to get 3 times the valued amount of his shares in the larger valuation, which already had heavily inflated pricing, simply because the purchaser wanted to acquire all the shares. Because without acquiring all the shares, it would have this individual out there whom they would have no control over, not ever be able to amalgamate the company or otherwise put protections in with respect to the company, move it forward, deal with stuff strategically, and the like. So they have this individual had to get paid out 3 times the value. Now, what is the issue that we have here? The issue is that this could have all been avoided. And it was considerable. It wasn't just the 3 times, it was all the legal fees that also went into trying to resolve this and move it forward, both with the acquiring company as well as with this individual, their lawyer, the negotiations that went on, so on and so forth. So what is strongly suggested? You want to have controls with respect to when you issue shares. You simply don't want to say, I'm issuing you shares, especially where, as in this example, the individual was gone in a very short period of time. So the compensation that he was receiving was well out of whack with what he was negotiating for. It's quite possible you could, when you look at it, let me think now when I think back at him. What he was effectively bought out with could very well have been close to a full year's salary by itself. And that is in addition to what he was getting paid. It could have well been more. And is that something really the company wants to do when it has to buy out people? That is not what your objective should be. That is not what you should allow yourself to be put in a position of. Instead, you need to have strict controls from the outset. Do not simply write this stuff out without consulting with a knowledgeable lawyer. Do not give stuff away. You need to be able to retract it. You need to be able to say, you know what? If you work out, you get to keep those shares. If you don't work out, you're not entitled to those shares. Or we buy them back for whatever we value them at the outset. That is what you need to be doing. Because without that, you get into the scenario of our cautionary tale, and it could be far worse than what even we say. And the cost was substantial. The cost was really substantial in this particular incident. So you don't want to necessarily do this simply because you don't engage legal counsel when you're making some deviation from a standardized employment agreement. And even then, and for reasons we talk about in other YouTube videos, you need to have a solid employment agreement with everybody you're working with. But when you're moving to give out shares to employees, you need to have it fully assessed. You need to be talking to legal counsel and understanding what the implications are and how to protect against those implications, working against your better interest. Well, once again, I hope you found this YouTube video informative. When you're looking for legal advice, we are an operating law firm, and our information is contained in this YouTube video. And we wish you all the best and success with operating your business, moving it forward, having great shareholders, having shareholders who are working with you and not against you, and taking on successful business transactions. Thank you.